All right, good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and so I do encourage you to speak to your attorneys before speaking on the record today, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here on misdemeanors or municipal ordinance matters, but understand that is dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at first appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. As we are getting started this morning, I have, I believe, 2 cases that have been requested to be called out of turn. I believe these are both at Maine.
Correct, Judge. And on page 6, Mr. Mobley.
Yes, and he has family present in the courtroom as well.
Thank you, Judge.
All right. Good morning, Mr. Mobley. This is Tripp.
Oh, I'm sorry, there's no.
Page 20, Mr. Tripp was the second
okay.
individual.
All right, we'll start with Mr. Mobley. All right, Mr. Mobley, you're before the court this morning on 2 charges. Count 1, touch or strike battery, domestic violence. Count 2 is a felony probation violation, which has a no bond hold. I find probable cause for these charges. I do see, Mr. Mobley, you're going to have a hearing with your division judge tomorrow morning to address the violation of probation. Before I hear from the parties, ma'am, are you here just to observe or to speak this morning?
To speak.
All right, a couple of things that I say to everyone who comes to first appearances. Number 1, everything that we say, that's all right, everything that we say is being recorded and can be used against you and potentially him at a later date. I say that to you because I don't know if you've spoken with law enforcement, but you're here without an attorney this morning, so I need you to understand that.
I know.
Okay, number 2, I'm not here to address any of the underlying facts or background of this case. We're only talking about bond and release conditions. Right. You understand? Okay, so if you want to speak, I'm going to place you under oath and then I'll hear from you, okay? All right, will you please raise your right hand? Do you swear or affirm to tell the truth? Thank you, and now you can put your hand down. I'm going to have you state your full name for the record and just speak into that microphone so that they're able to hear you at the jail, okay?
Okay.
All right, go ahead.
Kendra Morris.
All right, Ms. Morris, and what is it you would like to tell us today?
The reason why I'm here is because we're engaged, but everything, I'm here because of him. Like, I'm from West Palm, but I moved to Miami to start my family with him. Okay. This has never, ever happened, ever, I promise. Everything was a misunderstanding, but rent is due, and I'm down. I really don't know Miami like that, but him. Mm-hmm. So I'm just frustrated because I'm here because of him. Mm-hmm. You know, he's not a bad person. We go to church together and everything. Like, we're trying to better ourselves. everybody got faults. And when I try, I don't know if I can say that part, but when I tried to explain to the officer what it was not what it was. And the officer understood me, but it was just, I guess, them. And he was like, this maybe the state attorney, he was like, don't file anything. Don't write anything, And I still speak to the officer today.
Okay.
The reason why I'm here because um, it's just, this is his child. She's one. He pays daycare. He does all these things. I can't go to work because of this.
Okay.
He takes them in the morning for me and stuff. I work way on Bird Road, and I'm from West Palm, and I have the GPS myself certain places, but he knows where stuff at. Like, he's teaching me. I actually like living down there.
Okay.
It's just messed up. Rent, stool, water, light, and I don't know where that stuff at. He knows.
Okay. All right, Ms. Morris, I understand everything you said. I know that it's a frustrating process.
Yeah, it is.
I want to explain to you that what I'm going to do next is go to the attorneys to hear their recommendation to the bond.
Right.
But I want you to understand that because he has this felony probation violation.
Yeah, and
Okay, that's all
I'm
right. Just
sorry.
listen for a sec.
I'm sorry.
That's okay. He's going to have a hearing with his division judge on that tomorrow morning. So
Okay.
whatever we discussed today as far as count
Right.
one goes,
Right.
I want you to know he's not going to be getting out today because he'll have to go in front of his judge tomorrow.
Right.
You understand?
Yes.
Okay. All right. Let me first hear from the attorneys and then we'll come back to
Okay.
readdress some of these other issues. All right, Mr. Linder, we'll go to you first.
Thank you. Judge, I'm going to be requesting a $1,500 bond on count one,
Okay.
no victim contact. So the court's aware Mr. Mobley was, the charges he's on probation for are aggravated assault against a law enforcement officer, possession of a firearm by convicted felon, carrying concealed firearm, fleeing and eluding. On the top counts, he was sentenced to 10 years probation as a habitual offender. He's also been to state prison in the past out of Dade County for attempted murder, robbery with a firearm or deadly weapon, aggravated battery, and aggravated assault.
Judge, as you heard from the alleged victim, Mr. Mobley's fiance, there's been no prior history of violence between them. He's been here his whole entire life. He's 43 years old. My understanding, Judge, is his fiance does not want to prosecute, does not want to go forward on these allegations. In fact, my understanding is she was telling law enforcement officer not to arrest Mr. Mobley. His family depends on him. He's a primary financial provider. He works for Concrete Connections. He's been employed with that company for 1 year right now. My understanding, Judge, is I did advise him that the state's going to be recommending a no contact order. I advise him on domestic situations. The court almost always does that. However, Mr. Mobley has requested for me to ask the court not to impose that no contact order. I believe the victim is not in fear and wants to have contact with Mr. Mobley. He wants to be there in order to provide for his fiance and his two kids. But Judge, considering this is a misdemeanor offense, the victim is there present, I'm going to be asking for a $500 bond on Mr. Mobley and requesting the court not to impose a no contact order.
All right, I am going to, as far as count one goes, the bond is going to be set at $750. I need both Mr. Mobley and Ms. Morris to understand something that Mr. Romero has just referenced, which is the no contact order. In situations like this, and Ms. Morris, I understand everything that you've said to me, okay? In situations like this, I almost always, with very few exceptions, impose a no contact order. I understand the circumstances and what you are telling me today. I've heard what Mr. Romero has told me on behalf of Mr. Mobley, but it is my job as the judge in this matter for first appearances to take into consideration everything. That includes what's been said in the probable cause affidavit, okay? So for the safety of everyone involved, I almost always impose the no contact orders. That is until further order of the court. So until another judge lifts that order, that means no contact, okay? So I'm going to provide the reduced bond. I'm not going as low as $500 in light of some of Mr. Mobley's history, but I'm going to set it at $750. He's going to have to go in front of his division judge tomorrow to deal with the violation of probation issue anyway. But for the time being, I am going to impose the no contact order. Mr. Mobley, you need to understand the no contact order applies to you, okay? So until further order of the court, that means no being in the same place at the same time, no phone calls or text messages, and no third-party contact or social media contact. Now, I understand that there are children present. There may be some coordination that needs to be done with regard to the children. If that needs to happen, then I'm willing to let you do that through a third-party mediary as long as you're not together or having contact over that. Do you understand that, Mr. Mobley?
Yes, ma'am. I need to let her know where to go get the money to do it, like handle some things for me, handle some bills and stuff like that. I
Okay.
need, you know what I'm saying, like my car.
Is there
my car
someone
situation.
else? Is there another family member or friend that you're able to call to have that conversation with?
Really, ma'am, I ain't got nobody but myself and my kids and God. You know what I'm saying? I don't really got nobody out there.
Okay, well,
Nobody.
I tell you what, and Mr. Romero can discuss this with you further, but since you have this violation of probation hearing tomorrow morning, I assume, and Mr. Miller or Mr. Romero, you can correct me if I'm wrong, but I assume that the public defender's office probably represents him in that case. Is that correct?
He'll be signing up for it.
Okay, so you can discuss that issue with your attorneys and see the best way to proceed in that matter. Okay, Mr. Mobley?
Yes, ma'am.
Okay, all right. Thank you very much, and good luck to you both.
Judge.
Yes.
But, for the time being, you will allow, he's gonna try and reach out to his sister to let her know how to communicate with his fiance as far as paying the bill.
That's
So
fine.
to a third party, that's okay?
That's fine.
Thank you, Judge.
Okay. All right. Good luck, Ms. Morris. All right, our other case that was requested to be called out of turn is Clinton Tripp on page 20.
He's approaching, Judge.
Thank you. All right, good morning, Mr. Tripp.
Good morning, ma'am.
Mr. Tripp, you're before the court this morning on a violation of parole. I find probable cause. And Mr. Tripp, since this is a parole violation, it has a no bond hold, which means that you'll go before the parole board in order to address how that matter is going to be handled. Good luck to you, sir. All right, before I go to our sign-ins, is there anyone else that the jails need called out of turn?
Not at main, Judge.
Okay, Mr. Miller, any of the satellites?
And that I'm aware of, Your Honor.
Okay, we'll go ahead and go to some of our sign-ins if they're present at the jails. The first on my list here is Andre Boubet on page 14. He has family present in the courtroom.
Judge, he's a medical reset.
Okay, all right, ma'am, are you here on that case? All right, just so that you know what? Let me first ask this. Is the public defender's office representing him in this case? Because I see it as a status hearing and they're all capiases. Okay.
Boubet, here, I'll show you.
Beoubay.
Traffic misdemeanor.
Okay. He's on page 14.
Yeah, I know. Does he? She just sees Judge tomorrow.
Judge, he does not have an attorney on any case.
Yeah, all right. Well, since these are capiases, what I'm going to do is I'm going to go ahead and make a finding of probable cause in absentia since they're just capiases on all 5 counts. He has a hearing. Ma'am, you're here on this case, right? Okay. Since he's a medical reset today, which means he's not going to be coming into first appearance court today, but It means he may not be feeling well. There could be some issue as to why he didn't come down. You'll have to contact the jail because I don't have any control over that. But just so that you know, he is scheduled to go in front of his division judge tomorrow morning. So he'll have a hearing on that, okay? So I'm going to go ahead and make a probable cause finding now so he won't have to come back here. He can go straight to the division judge to address these other cases, okay? So just so you know, he's scheduled to have a hearing tomorrow at 9 a.m. with his division judge, all right? Okay, well, I'm telling you, he's not going to be here today. He has a court hearing tomorrow morning. He does have bonds. Okay, next is going to be, if he's present, it'll be Christopher Ruiz. He's on a number of pages.
Oh, he's here, present, Judge.
Thank you. The Hollywood detective is here on this case.
Yes, Judge.
All right. Okay. Good morning, Mr. Ruiz. Mr. Ruiz, you're before the court this morning on a total of 75 counts. Count 1 is for aggravated assault with a deadly weapon, domestic violence. Count 2, child abuse without great bodily harm. Count 3, touch or strike battery, dating violence. Counts 4 through 75 are each a separate count for possession of weapon or ammo by a convicted Florida felon.
Judge, of course, we have an argument for counts 4 through 75.
5 through 75? Go ahead.
Judge, they're counting bullets, and they're not allowed to do that. So we'd ask you to be ROR'd on those counts, please.
Your Honor, I'm not going to be asking for bonds to be set on all of them, but I believe that there's probable cause for all of them. It's two different issues. I'm going to be, assuming the court finds probable cause, I'm going to be asking for the court to set a bond for every count of every different type of ammunition that was found.
All right, as far as probable cause goes, I will make a finding of probable cause. Obviously, I'm going to take the specific facts into account when we're arguing bond, so we'll go to that in just a moment. All right, Mr. Linder, we'll go to the state first.
Yes, Your Honor, I'm going to be requesting a $20,000 bond on count 1, based on the allegation that he put a gun to the victim's head and threatened her. $5,000 bond on count 2, a $2,500 bond on count 3, $7,500 bond on count 4, and a $2,500 bond on counts 5, 6, 7, 8, 9, and 10. There were 6 different, by my count, there were 6 different types of ammunition that were located. I'm also going to be requesting a GPS monitor, pretrial GPS level 2. No contact with either of the alleged victims and the alleged witness, who would be Sierra Osorio. Your Honor, I've spoken with Detective Alonzo, who's present in court. He's investigated this case. He has advised me the victim is in fear of Mr. Ruiz and has safety concerns. He was arrested last year for robbery by sudden snatching and domestic violence battery against the same alleged victim. Those charges were dropped. He has a 2015 possession of methamphetamine out of Broward, out of Hillsborough County in 2015, burglary of a structure, grand theft. 2015, burglary of a structure, grand theft of a firearm, felon in possession of a firearm. And 2015, uttering a forged instrument, grand theft. Additionally, Your Honor, I'm showing he has 2 outstanding warrants out of the states of Texas and Indiana. Both warrants were issued in 2014. Out of Texas, it's for a burglary. Out of Indiana, it's for a DUI. Nothing further.
Are those states extraditing or are they just in state pickup?
No, it's, I think, surrounding areas in Texas and Indiana only.
All right. Mr. Romero,
Judge, when you add everything up, that's something Mr. Ruiz cannot afford. My understanding is self-employed, he's a barber. He does understand, as far as the no contact, he'll be living separate and apart from the alleged victim. He'll find a place, Judge. He's been residing in our community for the past 5 years. He's 35 years old. Judge, at this time, the only person that he can reach out to help post his monetary bond is his mother, who I intend on contacting. But my understanding, speaking with Mr. Ruiz, she is retired, so her financial resources are limited. So therefore, Judge, I understand the nature of the allegations. They're serious, but unfortunately, Mr. Ruiz cannot afford to pay that much. On count 1, we're going to be requesting a $4,000 bond. On count 2, we're going to be requesting a $3,000 bond. On count 3, I believe the state asked for a $2,500 bond. We're okay with that. And I believe on the possession of weapons or ammo, I'm going to be requesting a $1,000 bond, Judge.
on all of the counts related to possession?
No. Only on the, I believe on the first ammunition. I'm not taking into account the different or various types of ammunition, Judge. They're
Okay,
We can't afford-
how much did you request on that?
$1,000.
And obviously, Your Honor, while I wouldn't expect the court to set a bond per bullet, I would ask the court to take into consideration the amount of ammunition that was found. 71 rounds, considering he's not supposed to be in possession of any to begin with.
Okay. The bond on count 1 is going to be set at $10,000. The bond on count 2 will be set at $3,000. The bond on count 3 will be set at $2,500. The bond on count 4 will be set at $5,000. The bond on counts 5, 6, 7, 8, 9, and 10 will be set at $1,000 each. If Mr. Ruiz does post his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will be an order of no victim contact that pertains to each of the alleged victims in this case, as well as no contact with the witness, whose initials are S.O. As a condition of his pretrial release, he will also be subjected to random drug and alcohol testing. And there will be an order that he possess no weapons, firearms, or ammunition, which should go without saying based on his current status, but I'm going to say it anyway. Mr. Ruiz, so that you understand the no contact orders with regard to the 3 individuals that I've listed, that means no being in the same place at the same time as any of these individuals. Since you will be wearing the GPS monitor, that will include a 500-foot stay-away order from each of these individuals. The no contact order also includes no phone calls or text messages to any of these individuals, and no third-party contact or social media contact with them. Do you understand that, sir?
Yes, Your Honor.
All right. Additionally, I just want to make sure that you understand my other 2 orders. One is that as a condition of your release, you'll be subjected to random drug and alcohol testing. That means no alcohol, no intoxicants until further order of the court. And with regard to the order that you possess no weapons, firearms, or ammunition, that means that if you are in possession of any of these items, they are to be surrendered to local law enforcement. Do you understand what I've said?
Yes, Your Honor.
All right, thank you very much.
And Judge, we're gonna be also requesting a photo order so we can photograph Mr. Ruiz's injuries.
That's fine, I'll send it. I'm sorry, what was that, Shane? They're gonna be ROR. Yep. All right, let me just make sure I write all this out. Lady, on these other, I did the first few, will you change these other ones to all of us? All right,
Your Honor,
yes.
North Broward called and asked if Mr. Leslie can be taken out of order. He's on page 26 of the court's docket.
Leslie's last name? Is that
27.
Romario Leslie? Romario Leslie?
Yes, ma'am.
Thank you, Your Honor. Thank
You're
you, Mr. Miller.
welcome. Thanks, Deputy. All right, good morning, Mr. Leslie.
Good morning.
Mr. Leslie, you're before the court this morning on one charge of aggravated fleeing with injury or damage. I find probable cause, and I will hear from the parties.
I have to check to see if he has any history.
Okay, go ahead.
Your Honor, I don't see any history. I'm going to be requesting a $2,500 bond considering he was fleeing from law enforcement and collided with another vehicle while fleeing from law enforcement.
Judge, we're seeking $1,000 bond. Mr. Leslie has been living in South Florida for 15 years. He's been at the same address for the past 4 years. He works for Postmates. He does have a place to stay when he is released.
All right, the bond will be set at $2,000. Okay, good luck to you, Mr. Leslie.
Thank you.
You're welcome.
Thank you, Your Honor.
All right, now we're gonna go to our municipal ordinance cases, since we have Mr. Plant here. If I have them present, first up on page 2 will be Kayla Mullins.
Mayor, Your Honor.
Okay,
Thank you, Judge.
thank you.
Approaching Judge. There's Mr. Plant.
All right, good morning, Ms. Mullins.
Good morning, ma'am.
Ms. Mullins, you're before the court this morning on a municipal ordinance violation for trespassing. I find probable cause. Mr. Plant, who is your attorney for today, is with me here in the courtroom. And Mr. Plant, what are we doing with Ms. Mullins' case?
Judge, her offer is adjudication withheld.
Withhold adjudication, court
Yeah.
costs, no return?
Yes, no return. Yes, Your Honor.
All right, Ms. Mullins, if you want to resolve this case today, the offer will be a withhold of adjudication plus court costs, and there will be a no return order to the Rock Bar, which is the location that's at issue in this case. Do you understand that, ma'am?
Yes, I understand.
Do you wish to accept that offer today?
Yes.
All right, I'm going to ask you a few questions before we're finished. To begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. All right, and Ms. Mullins, do you understand everything we've discussed so far this morning?
Yes.
Is there anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
And Ms. Mullins, what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. So once again, your sentence will be a withhold of adjudication plus court costs, and there will be the no return order that we discussed. And you understand that?
Yes.
All right, Ms. Mullins, thank you very much. Good luck to you.
Thank you.
You're welcome.
Good luck, ma'am.
Next will be Tiara Holiday on page 3. Is she at Maine?
It's WOM.
Where is she?
Mr. Plant, she said Paul.
Paul Ryan.
Okay.
Plant?
All right. Hi, Deputy.
How you doing?
Good, how are
She
you?
refused. She went back to the unit. You want me to call her?
Mr. Plant, what do you want me to do? She's got, well, I guess this is with both of you because she's got
Yeah,
both the
everything.
state case and the MO cases.
Extradition case.
Yeah, and I see she's got the extradition. Mr. Miller, does the PD represent her?
Yeah,
They do?
we talked about her.
Okay. All right.
We should have her.
She has a court date tomorrow.
Okay.
And an extradition issue.
All right.
So we would ask the court to waive her presence
Yes, Your
and push her through.
Yes.
Okay.
In my case, is a warrant.
All right, so in this case, I'm going to make a probable cause finding in absentia. I will leave the bonds in place as they are, and she'll see her division judge tomorrow morning. Okay? Thank you. Next up is Urson Jean on page 14.
I'd main, Your Honor.
Thank you.
Judge, he's here and he's gonna require a Creole interpreter. I believe my colleague, Mr. Miller, may have already contacted, the interpreter's office.
Okay. All right,
I have your honor.
I'll place him on recall until we have the Creole interpreter. Thank you. All right, and next up will be Nathaniel Mays on page 16.
He's approaching, Judge.
Thank you. All right. Good morning, Mr. Mays. Mr. Mays, you're before the court this morning on 2 misdemeanor capiases. These are for municipal ordinance violations. Both are related to lodging on privately owned property. I find probable cause, and your attorney, Mr. Plant, is with me in the courtroom. And Mr. Plant, what are we doing with Mr. Mays' cases?
Your Honor, his offers on both are adjudication time served, but he has a brand new case, NTA, is Judge Powell, March 26th at 1:30.
March 26th?
At
Okay.
1:30, so we don't
All
want
right.
to miss that.
So, Mr. Mays, a couple of things. Number one, if you want to resolve these 2 cases today, the city's offer to you is an adjudication time served. Do you understand that?
Yes, ma'am.
All right. Do you wish to accept that offer today?
Yes, ma'am.
Oh, don't forget, you go to Judge Powell at the Hollywood Courthouse on that one, okay?
Yes, ma'am.
Okay, all right. So let me ask you a few questions before we're done with these other 2. Will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can put your hand down. And Mr. Mays, do you understand everything we've discussed so far today?
Yes, ma'am.
Is anyone forcing you to resolve these cases?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yeah, like 3 months ago. Yeah.
Okay, that's all right. Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
Okay. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And Mr. Mays, what plea do you wish to enter? Guilty or no contest?
Just get it.
Okay. I accept your plea and find that it's freely and voluntarily given. As we discussed, your sentence in these 2 cases will be an adjudication with time served. And please do not forget to go on your court date on March 26th.
March 26th, yes, ma'am.
Yes. All right. Good luck to you, sir.
Yeah, thank you.
I'll wait for.
Okay. I'll put that on our mail call. All right. So now, while I'm waiting on the Creole interpreter to come on Mr. Jean's case, I'll continue down our list. Next up will be Shada Dunkley.
She's here, main judge.
Thank you. Good morning, Ms. Dunkley.
Good morning, Your Honor.
Ms. Dunkley, you're before the court this morning on 3 charges. Count 1, aggravated battery causing bodily harm or disability, dating violence. Count 2, assault, dating violence. Count 3, criminal mischief, $200 or less. I find probable cause, and I will hear from the parties.
Judge,
I'm
we can't hear
sorry,
anything.
I'll repeat it.
35, I got it, I had it on mute.
Okay.
$3,500 bond on count 1,
Yes.
a $500 bond on count 2, not asking for any bond on count 3.
That's reasonable, Judge.
And no victim contact.
All right. All right, there will be, the bond on count 1 will be $3,500. Count 2 will be $500. There will be an order of no victim contact. Ms. Dunkley, so that you understand the no victim contact order as it relates to the alleged victim in this case, that means no being in the same place at the same time as this person. That includes no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that, ma'am?
Yes, Your Honor.
Thank you very much. Good luck.
Judge,
you.
a photo order as well.
That's fine. I'll sign that. Next will be Teresa Marie Williams.
North Broward.
Thank you. All right. Good morning, Miss Williams. Miss Williams, you're before the court this morning on 1 charge of battery on a person 65 years of age or older.
That is my mother.
Hold on 1 second. Miss Williams, 1 moment, please.
Ms. Williams, I thought we agreed you were gonna let me do the talking. Okay.
All right. I find probable cause, and I will first hear from the state, and then we'll go to Mr. Miller to hear from the defense.
Your Honor, I'm going to be requesting a $5,000 bond, no victim contact. Ms. Williams was arrested February 10th of this year for possession of alprazolam. She's out on a $1,000 bond. Last year, she had priors for unlawful use of false name ID, resisting without violence, and possession of drug paraphernalia. She had 2 separate prostitutions last year. Prostitution 2018, drug paraphernalia 2018, prostitution 2017, possession of cocaine 2017, possession of cocaine 2017. She had 2 counts of battery 2002.
All right, Mr. Miller?
Yes, ma'am. Ms. Williams is a 40-year resident of South Florida. She's been in her current address for 10 years. She does have a place to stay that is separate and apart from the alleged victim in this case. She's currently unemployed, however, she does work in the restaurant industry. She does support her 10-year-old, even though he is living with the mother at this time. We're asking the court for $1,000 bond.
I,
All right, in light of the fact that Ms. Williams is out on bond in another felony case at this time, I'm not going to revoke her bond in that case, but I will set the bond in this case at $3,500. There will be an order of no victim contact. Ms. Williams, so that you understand the no victim contact order, with respect to the alleged victim in this case, which you have told me is your mother, that no contact order means no being in the same place at the same time, that no contact order includes no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
I do.
All right, thank you very much. Good luck to you, ma'am. Lisette Michaud.
She's at the Paul Ryan facility.
Okay.
I spoke with her this morning.
Yeah.
All right, Your Honor.
Is this her?
She believes that Jeffrey Weiner is her attorney. I spoke with Mr. Weiner's office. She has not retained him on this matter. She is a Creole speaker. She does understand English, but in an abundance of caution, I've asked that the Creole interpreter be involved in this case.
Okay, all right. I will, I'm gonna put Ms. Michaud's case on recall for a few minutes. When the Creole interpreter comes, then I'll call her back.
I don't speak English.
Okay.
Thank you. All right, Tanisha Scott Jones.
Judge, she's at North Broward. We're looking to resolve this case if the court is so inclined.
All right, let's have a look.
North Broward.
I'll do this case and then I'll do the other two. All right. Good morning, Ms. Scott Jones.
Morning.
You're before the court this morning on a misdemeanor capias. This is related to a charge for operating without a valid driver's license. I find probable cause. And Mr. Leonard, does the state have an offer in this case?
Withholding court costs, Judge.
Withholding court costs? All right. Ms. Scott Jones, if you would like to resolve this case today, the state's offer to you is a withhold of adjudication plus court costs. Do you understand that?
Yes.
Do you wish to accept that offer today?
Yes.
All right, I'm going to ask you a few questions before we're done. To begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. And now you can put your hand down. And Ms. Scott Jones, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
Just to kind of understand, I would like to speak with him.
You want a few minutes to speak to him?
Yes.
Okay, all right. I'll give you a minute. He's going to call you there on the phone at the jail so you can speak to him privately for a minute, and then I'll bring you back.
Okay.
Okay? Why don't I go to, while Mr. Miller's doing that, why don't I go back to our last MO case at Maine? We'll recall Urson Jean.
He's approaching, Judge. Mr.
Thank
Jean,
you.
come on up, please.
And for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Creole to English and English to Creole to the best of your ability? Thank you, Ms. Sanders.
An entrepreneur works for about 1,000. You get assistance from the government. Be one of those properties.
Israel Cannon.
What is that?
All right. Good morning, Mr. Jean.
Bonjour, Monsieur Jean.
You're before the court this morning on a misdemeanor capias.
Pour yon amende arrestation.
This is related to a municipal ordinance violation.
Ça, c'est pour yon violation dans ville là.
The charge is for trespassing.
Parce que vous t'es entré en côté illégal.
I find probable cause.
J'ai une cause probable.
Your attorney, Mr. Plant, is with me here in the courtroom.
Avocat ou Monsieur Plante, li là ensemble avec le tribunal là.
And Mr. Plant, is there an offer in Mr. Jean's case?
Gen yon offre pour Monsieur Jean.
Yes, Your Honor, it's adjudication,
Oui, juge.
time served,
On va parler pour qu'il était passé dans la prison.
no return to the
Et pour parler tourner dans
place he was trespassed at.
côté que t'es entré illégal.
All right.
And he has court tomorrow if he doesn't want.
Li gen tribunal demain s'il va accepter.
Mr. Jean, if you would like to resolve this case today,
Monsieur Jean, si vous avez résoudre cas jeudi,
the city has made an offer to you.
l'État a offert une négociation.
It would be an adjudication of guilt
Il a condamné au coupable.
plus time served,
Ou a gagné, ou a bon crédit pour tant qu'on déjà fait dans prison.
and there would be a no return order to the location of trespass.
Et puis a gagné l'autre qui passe pour pas jamais retourner dans et côté côté entrée illégal là.
Do you understand that, sir?
Est-ce que vous comprenez?
Yes. Yeah.
Do you wish to accept that offer?
Vous voulez accepter offre ça?
Yeah.
Was that a yes?
Oui, vous voulez accepter?
Répétez pour moi encore.
Vous voulez accepter offre que yo bon là?
Oui.
Yes.
All right, I'm going to ask you a few questions before we're done.
Je vais poser quelques questions avant que nous finissions.
To begin, will you please raise your right hand?
Levez mes doigts tout.
Do you swear or affirm to tell the truth?
Est-ce qu'on fait serment affirmé pour dire la vérité?
Yeah.
Yeah.
All right, you can put your hand down.
Mettez ça de main.
And Mr. Jean, do you understand everything we've discussed here this morning?
Monsieur Jean, est-ce qu'on comprend tout ça que nous sommes parlé de yo là, matin?
Yes.
All right. Is anyone forcing you to resolve this case?
Est-ce que gen moun qui force ou pour résoudre cas?
No.
Are you under the influence of drugs or alcohol?
Est-ce qu'on sous effet drogue avec alcool?
No.
Do you need any more time to speak with your attorney?
Est-ce qu'on besoin plus de temps pour parler avec avocat ou?
Just really busy finir ça mal travail.
I just want to be done with this so I can go back to work.
Okay, just a few more questions.
Juste répondre question yo.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea?
Est-ce qu'on comprend que vous avez droit pour aller dans le jugement, mais vous perdez droit ça, parce que vous renoncez à droit ça pour capable accepter offre là?
No. Huh? Yes.
Yes.
Do you understand that,
Vous
sir?
comprenez?
Off ya bon moyen.
The offer?
I'm going to ask you this question one more time.
Ma pose question encore.
Do you understand that you have the right to trial,
Est-ce qu'on comprend que vous avez droit pour aller dans le jugement,
but you are waiving that right by taking the plea offer today?
mais vous avez quitté droit ça pour capable accepter offre que vous offrez aujourd'hui?
Yeah.
Yeah.
Okay. Have you ever been treated for mental or emotional illness?
Est-ce que vous j'aime très tôt pour problème mental?
No.
No.
All right. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Est-ce qu'on comprend si que vous pas un citoyen américain, offre ça que vous acceptez à capable faire que vous déportez ou?
Yeah.
Was that a yes or a no?
Oui, vous comprenez?
Yeah, me comprends.
Yes, I understand.
All right, and Mr. Jean, what plea do you wish to enter? Guilty or no contest?
Ki jon ve deklare koupab ou bien ou pa konteste?
Ça me le dit là. Ça pour me dire.
What should I say?
It's your choice, sir.
Se chwa ou, monsieur?
You can say no contest,
Ou kapab di ou pa konteste?
so you don't contest
Ok,
the
m'a
charge.
contesté. D'accord.
Okay, I'm
Back
not
on.
contesting.
Okay. All right, Mr. Jean, I accept your plea and find that it is freely and voluntarily given.
M'aksepte off la e mwen ke ou fe la ke tout prop volonte ou.
As we discussed, your sentence will be an adjudication, time
Jan ke nou
served.
so di la, santansou, se ke y ap bon kredi pou tan ke ou te pase nan prison, y ap kondane ou koupab.
And there will be a no return order to the location that we discussed.
E pi gen lòd ki pase pou pa retounen nan kote ou tantre ilegal la.
Do you understand that, sir?
Esko kompren,
Yes.
monsieur? Yes.
All right, good luck to you, Mr.
Bonne
Jean.
chance, monsieur.
Merci. Thank you.
You're welcome. All right, and then I have one other.
Thank you, Judge.
Thank you, Mr.
Ms.
Plant.
Shode in Hall Run Facility,
Yes,
Judge?
let's go ahead and take her case. All right, good morning, Miss Michaud.
Yes, Joanna.
All right, Miss Sainage, I need you for this last one, just in an abundance of caution.
Okay.
Okay,
What is the name?
Michaud.
Yes.
All right. Got it. All right, Miss Michaud, I have a Creole interpreter with us today.
Miss Michal gen yon interprète créole ansam avè nou jodi an.
I understand you speak a little bit of English,
M kompren ko palon ti anglais,
but I want to use our Creole interpreter just so that I know you understand everything.
men vle utilize interprète lan pou m ka asyure ko kompren tout bagay.
For the record, you're before the court this morning on 2 charges.
Ou nan tribunal nan la pou 2 akuzasyon.
Count 1 is for second-degree petty theft.
Akuzasyon 1, se pou yon ti vol 2e degré.
Count 2 is for criminal mischief
Akuzasyon 2, se pou mouvez konduit.
between $200 and $1,000.
Entre $200 et $1,000.
I find probable cause.
M jwen koz probab.
And Mr. Miller is acting as your attorney today. He's with me in the courtroom.
Monsieur Miller, se li ki avokat ki represente ojodi an, li la nan tribunal lan.
Is the state seeking anything beyond the $100 standard bond?
Eske l'Etat mande plus ke $100 kausyon an?
Just no return to this business.
Non, jist pou pa retounen nan business ankon.
All right, Mr. Miller.
Judge, okay, I just want to reiterate what I mentioned before, that Jeffrey Weiner is not Miss Michaud's attorney.
Jist vle fè konen ke Jeffrey Weiner se pa avokat Miss Michaud.
He has not been retained on this matter.
Yo pat payel pou sa.
The judge has asked me to help Miss Michaud this morning.
Juj la mande m pou m'ede Miss Michaud matin an.
My question to you, Miss Michaud, is can you afford $100 to bond yourself out?
Kesyon pou Miss Michaud, esko kapab paye $100 pou ka soti nan prison? I don't have money right now.
Okay. Do you have a place to live, Miss Michaud?
Esko gen kote pou habite?
No. Just stay in my car.
Do you work?
Wap travay?
No.
Judge, in light of the facts that these are 2 misdemeanor charges,
Kom se
and
2 ti krim grav, ti krim.
Miss Michaud does not have the present ability to post a $100 bond,
Miss Michaud pa gen mwayen pou paye $100 kausyon.
if the court would consider releasing her on her own
Juj
recognizance.
lan te ka aksepte konsidere la geli sou prop engajman.
Your Honor, frankly,
Sir?
I think this case should go to before Judge Lerner Wren.
Juj m pense ke kasa yo dwe pou voye sou tribunal juj Lerner Wren.
Mr. Miller, any objection to that?
No.
Gen sa pou di sou sa, non juj.
All right, what I will do is this. I'm going to leave the $100 bond in place.
Map kite kausyon $100.
I will sign an order transferring this matter to Judge Lerner Wren's division.
Map transféré kasa nan division juge Lenoren.
Ms. Michaud, you should be seeing Judge Lerner Wren within the next couple of days.
Miss Michaud wap gen pou wè avèk juge Lenoren nan kek jou.
We will see if there are any additional resources that she can offer which might help you.
Nap wè si juge sa ka genyen resous ke li kapab utilize pou ede ou.
In the meantime, there will also be an order of no return to the location this allegedly occurred at.
Entre-temps, gen lot ki pase pou pa retounen kote o tale a.
That means you're not to go back there. Do you understand
Ki
that?
ve tou pa dwe pou retounen la, esko kompran?
That is in my property. The reason I go there. It's okay I get arrested, but no, this should be done anyway. I'm glad to get arrested about that. Because I'm sending like that, 4 times to these people, and then they call police to arrest me. I'm glad this happened. But this should be done.
All right. Well, Ms. Michaud, you'll see Judge Lerner Wren within a couple of days.
Wap genyen pou wè avèk juge Lenoren nan kek jou.
Good luck to you,
That's
ma'am.
okay.
Bonne chance.
Is there anyone else at any of the facilities that requires a Creole interpreter while I have her?
Eske genyen lot moun ki bezwen interprète kreol?
Okay. All right, Ms. St. thank you. All right, let's go back to North Broward to see Ms. Scott Jones. Mr. Miller, were you able to speak to her? Miss Tanisha Scott Jones?
Judge, I believe I answered all of Ms. Scott Jones' questions, and she appears to be ready to go forward this morning.
Okay. All right, and this was a withholding court cost, correct?
And she just needs a year to pay, if that's okay, Judge.
That's fine. All right. Ms. Scott Jones, so you've spoken to Mr. Miller. Did he answer all of your questions?
Yes.
Okay, so let's continue on with the rest of my questions before we're done, all right?
Okay.
Okay, remember that you've been placed under oath, okay? So everything that you say needs to be truthful.
Okay.
All right, do you need any more time to speak with your attorney?
No.
All right, and do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Okay, have you ever been treated for mental or emotional illness?
No.
All right, and do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Ms. Scott Jones, what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence in this case will be a withhold of adjudication plus court costs. And Mr. Miller said that you might need some extra time to pay those court costs. Is that right?
Yes, please.
Okay, how much time would you need?
6 months to a year. I'm just looking for a job now. And as soon as I get some income, I will put money aside so I can pay it off in total.
Okay, I will give you a year to pay them, and I will allow you to make partial payments if that makes it a little bit easier to pay it a little at a time, okay?
Thank you.
All right, good luck to you, ma'am.
Thank you.
You're welcome. Okay, going down our list, next will be Tony Annette Raisback.
She's a medical research on it.
All right, thank you, Deputy.
You're welcome.
Marla DeUlis.
Also,
No problem.
Okay,
North Broward, Judge.
thank you. Good morning, Ms. DeUlis. Ms. DeUlis, you're before the court this morning on 8 charges. Count 1, possession of a controlled substance without a prescription. Count 2, DUI, alcohol or drugs, 4th or subsequent offense. Count 3, DUI with blood alcohol content greater than 0.15. Count 4, DUI with damage to property or person of another. Count 5, resisting an officer obstructing without violence. Count 6, leaving the scene of a crash involving damage to property. Count 7, following too closely. That is not for magistrate. Count 8, resisting an officer obstructing without violence. I find probable cause for these charges, and at this time I will hear recommendations from the parties as to bond and release conditions.
For the
I'm
state.
requesting a $7,500 bond on the 4th DUI.
On which one, I'm sorry?
2.
2, okay.
Should she post her bonds, I'd ask that she be supervised by pretrial. random testing, TAD monitor, no driving until further order of the court.
Mr. Linder, when was the last DUI?
1995, 1993, 1990. She had another arrest for 1995 in Pennsylvania for DUI. That was dropped, Your Honor, under the totality of the circumstances, and I can, based on her behavior, I can only imagine how intoxicated Ms. Dalius was. I think these bonds and conditions are appropriate.
Okay. All right, Mr. Miller, I'll hear from you now.
Judge, I would ask the court not to put her on the TAD monitor. 25-year-old charges out of another state. That being said, we'd ask that the bonds be kept as set, except for state's request in count 2. We'd ask that that be set at $1,000. Ms. Adelius has been living in South Florida since 2006. She's been in her current address for about 12 years. She works at a bank. She has 20 years working in a bank. She will be able to bond. She does have a place to stay. We are requesting a photo order so that we can record as evidence these injuries that she's received. And again, we think that the state's request for pretrial supervision is overkill under the circumstances.
Your Honor, and I would just note, according to the report, the injury she received because she did it to herself when she fell off a bench because she was so impaired.
I understand. I did note that in the report. I'm gonna set the bond on count 2 at $5,000. I will leave the other standard bonds in place. If Ms. DeUlis does post her monetary bond, she will be placed on standard pretrial supervision and subjected to random drug and alcohol testing. I will not impose the tab monitor at this time, but there will be an order of no driving until further order of the court. Ms. DeUlis, with regard to the condition that you're going to be subjected to random drug and alcohol testing, that means no alcohol, no intoxicants until further order of the court. Do you understand that?
Yes, I do.
And with regard to the order that you not be driving, that means that you are not to be driving any motor vehicle until further order of the court. Do you understand that?
Yes, I do.
All right, thank you.
And the photo order, Judge?
I'll sign the order.
Thank you.
Amber Velez,
$12,000.
thank you. All right, good morning, Ms. Velez.
Morning.
Ms. Velez, you're before the court this morning on 3 charges. Count 1, resisting an officer obstructing without violence. Counts 2 and 3 are each a separate count for a felony probation violation with no bond holds. I find probable cause. I do see you're going to have a hearing with your division judge tomorrow morning to address the probation violation issue. So in light of that, do the parties wish to be heard on count 1?
No, Your Honor.
No, Judge.
Okay, I will leave the $100 bond in place on that count. And Ms. Velez, as I said, you'll see the division judge tomorrow morning.
I didn't know that there were two violations.
Yes,
Can you
ma'am.
can you read those to
There
me?
are 2 separate violations because there are 2 case numbers.
One violation, 2
Oh, I
probations,
understand.
Judge.
Okay.
Okay, thank you.
All right, thank you, ma'am. Okay, next will be Jacob Mona. Thank you.
Main jail, Your Honor.
Good morning, Judge.
Good morning, Mr. Mona.
How are you?
I am well, thank you. Mr. Mona, you're before the court this morning on 2 charges. Count 1, grand theft between $750 and $5,000. Count 2, battery causing bodily harm, domestic violence. I find probable cause, and I will hear from the parties. All right.
Requesting a $3,500 bond on count 2. No victim contact. Mr. Mona was arrested last September for domestic violence battery against the same alleged victim. That charge was dropped.
Mr. Romero?
Judge, and speaking of Mr. Mona, he's 25 years old right now. He's basically self-employed. He's been doing that for 1 year. My understanding, Judge, he will be living separate and apart from the alleged victim. Judge, he has asked me to ask the court and request a $1,000 bond on count 2. He says he has that amount in property, so he could go ahead and self-bond. So that is why he is requesting a total of $2,000 bond on these charges before the court. And we're also going to be requesting a photo order as well.
No, we won't.
All right.
No, we won't.
Okay, no photo order then.
The bond on count 2 is going to be set at $2,500. There will be an order of no victim contact. Mr. Mona, so that you understand the no contact order with respect to the alleged victim in this case, that means no being in the same place at the same time, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All right, thank you. Christopher Grant.
He's approaching, Judge. He's here,
Thank you. Good morning, Mr. Grant. Mr. Grant, you're before the court this morning on 3 charges. Count 1, DUI, alcohol or drugs, first offense. Count 2, DUI with damage to property or person of another. Count 3, disobeying or avoiding a red light. That count is not for magistrate. I find probable cause, and I will hear from the parties.
Judge, nothing to add at this time. I'm going to be contacting Mr. Grant's family to post his monetary bond.
Anything from the state? All right, I'll leave the standard bonds in place. Thank you. Joel Hernandez Alvarez.
We're waiting on a Spanish interpreter. I believe Mr. Miller already contacted the interpreter's office, Judge.
Okay. Next will be Gabelin Filsame.
He's a medical research on it.
Okay, thank you, Deputy.
You're welcome.
He's a medical reset. Tyler Eugene Parsons.
He's approaching, Judge Maine.
Thank you.
Good morning, Your Honor.
Good morning, Mr. Parsons. Mr. Parsons, you're before the court this morning on 1 charge of disorderly intoxication in a public place causing a disturbance. All right. I find probable cause, and confinement has just advised me your bond has been posted, sir. So you'll be processed for release. Thank you. Robert Wolf.
Bonded, Judge.
Thank you. Don Bolton.
He's approaching, Judge Maine.
Thank you.
Mr. Bolton, come on up.
All right. Good morning, Mr. Bolton.
Hi.
Mr. Bolton, you're before the court this morning on a misdemeanor capias. This is related to a charge for petty theft. I find probable cause. I do see Mr. Bolton is scheduled for a status hearing tomorrow morning with his division judge. Do the parties wish to be heard?
Not at this time, Judge.
All right, thank you. Good luck, Mr. Bolton. Lee Eddie Thomas.
Approach, Judge Maine.
Thank you. Good morning, Mr. Thomas.
Good morning.
Mr. Thomas, you're before the court this morning on 2 misdemeanor capiases. These are related to charges for possession of drug paraphernalia and trespassing. I find probable cause. Mr. Romero, what would he like to do?
Judge, I'm speaking, Mr. Thomas, he wishes to resolve these matters today.
Is there an offer from the state? Okay.
The time served, no return to 2801 Northwest First Street in Fort Lauderdale.
Judge, I was explaining to Mr. Thomas the conditions of the plea offer, and at this time he says he wishes to accept that.
All right, Mr. Thomas, I'm going to ask you a few questions before we're done. To begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Mr. Thomas, do you understand everything we've discussed here this morning?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
And Mr. Thomas, what plea do you wish to enter, sir? Guilty or no contest?
Okay. No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served, and there will be a no return order to the location that was discussed. Do you understand that?
Yes.
All right, good luck to you, sir. Ronald Newman.
North Broward?
I spoke with North Broward. He's going to be a medical reset.
Okay.
Based on my conversation with the deputy there, wondering if the court would transfer this case to Judge Lerner Wren.
All right, that's fine with me. I will make a finding of probable cause in absentia. I will leave the bond in place, and I'll sign an order transferring him to Judge Lerner Wren's division.
Thank you, Your Honor.
Thank you.
Just want to see the case number.
All right, thank you, Mr. Miller. Okay, next up will be Matthew Post.
He's here at main, Judge.
Thank you. Good morning, Mr. Post. Well, per my picture here, are we sure this is the correct Mr. Post?
Your Honor, he was
So I know he's
arrested
been in custody
December
since
last
December,
year.
Oh,
so I don't.
okay, all right, I just want to make sure. I like to check. All right, Mr. Post, you're before the court this morning on a few ad charges. Counts 8, 9, and 10 are for second-degree petty theft. Counts 11, 12, and 13 are passing a forged or altered bill or promissory note. Counts 14, 15, and 16 are for making or issuing a check for insufficient funds. Counts 17, 18, and 19 are fraud, attempting to use ID of another person without consent. 20, 21, and 22 are for possessing similitude of driver's license. I find probable cause for these charges, and I will hear from the parties.
Judge, my understanding, Mr. Post's been in custody since December. I believe he's sentenced till April. So based on that, nothing to add at this time, Judge.
Okay, anything further from the state?
Judge.
All right, I will leave the standard bonds in place at this time. Good luck to you, Mr. Post. Travis Stewart.
Mr. Stewart, come on up, please. Judge, Mr. Stewart is approaching. He was asked twice. He declined the services of public defender. He's going to hire his own attorney, and he said he didn't want a public defender to report today.
All right.
Your Honor, count 2 should be between 10 and 200 grams.
I'm sorry, I couldn't hear you.
Count 2 should be between 10 and 200 grams.
Yes, that's what I figured. What's the standard bond on that? All right, while you're checking that, let me just read. Mr. Stewart, good morning.
Good morning.
Mr. Stewart, for the record, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yes, ma'am.
And are you declining the services of the public defender at this time? Was that a yes?
Yes, ma'am.
Okay, all right. And Mr. Stewart, you understand that Mr. Romero told me that you intend to hire private counsel. You can always have the public defender's office represent you today and hire private counsel later. You understand that?
Oh, I didn't know that.
Okay, well, does that change your mind at all?
Yeah.
Does that change your mind?
Yeah.
Okay.
Yes, ma'am.
So you do want to have the public defender represent you this morning?
Yes.
Okay, so I imagine they're probably going to need a few minutes to talk to you. So, Mr. Romero, do you need a few minutes to speak to Mr. Stewart?
Yes, and so do I.
Yes, Judge.
Okay, all right, Mr. Stewart, I'm going to put you on a brief recall so they can speak to you, and then I'll call you back up in a few minutes. All right. Jocelyn Burnett.
He's approaching, Judge.
Thank you. Good morning, Mr. Burnett.
Morning.
Mr. Burnett, you're before the court this morning on 3 charges. Count 1, possession of cocaine. Count 2, resisting an officer, obstructing without violence. Count 3 is for riding a bike with no light at night. That is not for magistrate. I find probable cause, and I will hear from the parties.
Judge, unfortunately speaking, Mr. Burnett, he's not in a financial position to post a monetary bond. He's financially indigent. At this time, unfortunately, he's homeless. He does have a mailing address. It's a friend of his who lives in Fort Lauderdale that he says he can use his address to get notices to make sure he comes to court. Now, he's been living in our community for well over 20 years. He's 54 years old. He did advise me he has prior contact with the criminal justice system, but nothing recent. Considering this is a non-violent offense, Judge, we're going to be asking the court to consider releasing him under pretrial release.
What's the mailing address?
What's the mailing address of your friend?
1529. Address 15 Court.
I've been advised the mailing address 1529 Northwest 15th Court,
Okay.
and that's in Fort Lauderdale.
That's what I'm showing on his booking information.
I don't have an objection to pretrial random testing, Judge.
All right. Mr. Burnett, I'm going to ROR you on count 1 and release you to pretrial supervision. As a condition of your release, you are going to be subjected to random drug and alcohol testing. So that means no alcohol, no intoxicants until further order of the court. You understand that, sir?
Yes, ma'am.
All right. Additionally, Mr. Romero has just handed you a paper with some information on it. Though you're going to be released today, you must report to pretrial supervision in person within 24 hours. If you fail to report to them as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Thank you. Good luck to you, sir. Next will be Corfrey Gregory.
Mr. Gregory, come on up. Judge, Mr. Gregory declined to serve as public defender.
Okay. All right. Good morning, Mr. Gregory.
Good morning.
Mr. Gregory, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yes.
And are you declining the services of the public defender at this time?
Yes.
All right. For the record, Mr. Gregory, you're before the court this morning on 6 charges. Count 1, resisting an officer, obstructing without violence. Count 2, fleeing or attempting to elude law enforcement. 3, operating without a valid driver's license. 4, 5, and 6 are felony probation violations, which have no bond holds. I find probable cause. Is the state seeking anything beyond the standard bond on 2?
No, Judge.
Okay, all right, Mr. Gregory, you're gonna have a hearing with your division judge tomorrow morning to address the violation of probation issue. So I'm gonna leave the standard bond in place on count 2, which is $1,000. Do you understand? Okay, all right, so you'll see the division judge tomorrow morning. You can address everything further then. Good luck to you, sir.
Appreciate it.
Kenyatta Jackson.
Mr. Jackson is approaching, Judge, and he declined to serve as a public defender.
Good morning, Mr. Jackson.
Good morning.
Mr. Jackson, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yes.
And are you declining the services of the public defender at this time?
Yes.
All right. For the record, Mr. Jackson, you're before the court this morning on 2 charges. Count 1, DUI, alcohol, or drugs, third offense within 10 years. Count 2, DUI with damage to property or person of another. I find probable cause for these charges, and Mr. Linder, I will hear from you first with the state's recommendation.
Your Honor, I'm requesting a $5,000 bond on count 1, a $1,500 bond on count 2, pretrial release, random testing, no driving till further order of the court. Your Honor, the court should be aware that from what I can see at the time of this accident, Mr. Jackson was on a 5-year driver's license revocation from his second DUI.
All right. Mr. Jackson, do you understand everything we've discussed so far this morning?
Yes.
All right, and you understand that since we're only here for first appearances, I'm only addressing bond and release conditions this morning, right?
Yes.
Okay, is there anything that you want to tell me about bond or release conditions?
No.
Okay. All right, so I will grant the state's request at this time. The bond on count 1 will be set at $5,000. The bond on count 2 will be set at $1,500. If Mr. Jackson does post his monetary bond, he will be placed on pretrial supervision and subjected to random drug and alcohol testing. There will also be an order of no driving until further order of the court. Mr. Jackson, I just want to make sure that you understand the conditions of release, okay? As part of being on pretrial supervision, you will be subjected to random drug and alcohol testing. That means no alcohol, no intoxicants until further order of the court. You understand that?
Yes.
All right, and additionally, there's going to be an order that you not be driving. That means that you are not to be operating any motor vehicle until further order of the court. You understand that?
Yes.
Okay, all right, thank you very much. Good luck to you, sir.
Thank you.
Bella Soder.
He's approaching, Judge.
Thank you. Good morning, Mr. Soder.
Good morning.
You're before the court this morning on 2 charges. Count 1, second-degree petty theft, third or subsequent offense. Count 2, trespassing on an occupied structure or conveyance. I find probable cause, and I'll hear from the parties at this time.
Judge, I did talk to Mr. Soder regarding the standard bond in place. Unfortunately, he can't afford that. Now, he's been here his whole entire life. He's 40 years old. Right now, he's looking for employment. Now, he does side work. He does air conditioning repair, but he says that's really, really slow, and that's why he's looking for other employment. He lives with his mother in North Lauderdale. His mother knows he is here, but she can't help post his monetary bond. She's on a fixed income, gets disability. So right now, no one's going to be able to help post his bond. Considering this is non-violent offense, Judge, I'm asking the court to consider releasing him on pretrial release today.
Okay, Mr. Linder.
One moment, Your Honor. Your Honor, the court should be aware that Mr. Soder just got off of DUI probation a little over a month ago after violating his probation. He also violated with picking up inhaling harmful chemical substances. He's got petty thefts, 2 petty thefts in Broward in 2018, trespass in 2018. Let's see. Another violation of his DUI probation in 2019.
You able to tell me what the violation was for?
The last one, yes, the last one was based on a new law offense. And the first one, he didn't go to the counseling center he was supposed to. He had positive urinalysis results for oxycodone on more than one occasion.
Judge, in speaking, Mr. Soder, I found out additional information. I haven't had an opportunity to review the PC affidavit, but my understanding when LPO, he was encountered, he was voluntarily went to the office, he waited there till LPO arrived, he was cooperative, he didn't try and run or escape or anything like that. I believe the alleged item was a battery with the value at around $50. Judge, once again, based on the totality, I know it's recent, his VOP, however, based on the fact that he can't afford it, he didn't try and run or escape. I'm asking for a pretrial release on his behalf, Judge.
I just want to correct something. Per the probable cause affidavit, it says it wasn't one battery, it was 3 car batteries with a total value of $290.
I'm not really sure, Your Honor, that not trying to escape is a mitigating factor at this point, Your Honor.
I understand. All right. Mr. Soder, I'm going to give you a chance and put you on pretrial supervision.
Thank you.
You're going to be ROR'd on count 1. There's also going to be a no return order to the Walmart that's at issue in this case. From what I'm reading, it looks like you were previously trespassed from that Walmart, so I shouldn't need to say that there's no return, but that means that you are not to go back there. Do you understand that?
Yes, ma'am.
All right. Though you're going to be released today, Mr. Romero has given you some information there. You must report to pretrial supervision within 24 hours. If you fail to report to them as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Thank you. Good luck. Bailey Frick.
Mr. Fricky is here, present, Judge, at Maine.
Thank you. Good morning, Mr. Fricky.
Good morning.
You're before the court this morning on one charge of carrying a concealed firearm. I find probable cause.
I'm going to argue. One moment, please.
What's your argument?
Never mind.
Okay. I'll hear from the parties.
Judge, nothing to have from the defense.
All right. Anything from the state? Okay. I'll leave the $1,000 bond in place. Thank you. Good luck, Mr. Fricky.
I'll call your mom.
Next will be Matthew McIlvain.
Mr. McIlvain, come on up.
Okay. Good morning, Mr. McIlvain.
Good morning.
You're before the court this morning on 3 charges. Count 1, possession or use of drug paraphernalia. Counts 2 and 3 are felony warrants for violations of pretrial. Those have no bond holds and are not for magistrate. I find probable cause. Do the parties wish to be heard on count 1 in light of the no bond holds?
No, Judge.
Judge, in light of no bond holds, nothing from the defense at this time.
Okay, I'll leave the $100 bond in place. Thank you. Good luck, sir. Israel Cannon.
He's approaching Judge Maine.
Thank you. Good morning, Mr. Cannon.
Good morning.
Mr. Cannon, you're before the court this morning on one charge of criminal mischief over $1,000. I find probable cause, and I will hear from the parties at this time.
Judge, at this time, I'm going to be requesting a SAP order.
All right, I will sign that order. Is there anything further from the state?
No, Judge.
All right, I will leave the standard bond in place, and I'll sign the SAP order that was requested. Mr. Cannon, good luck to you, sir. Jonathan Owens,
He's approaching, Judge.
thank you. Good morning, Mr. Owens. Mr. Owens, you're before the court this morning on 3 charges. Count 1, grand theft auto. Count 2, operating without a valid driver's license. Count 3 is a felony probation violation, which has a no bond hold. I find probable cause. I do see, Mr. Owens, you're going to have a hearing with your division judge tomorrow morning on the violation of probation. In light of that, do the parties wish to be heard on count 1?
No, Judge.
All right, I'll leave that standard bond in place. Good luck, Mr. Owens. Joshua Dundas.
Mr. Dundy.
Good morning, Mr. Dundas. You're before the court this morning on 2 charges. Count 1, possession of methamphetamine. Count 2 is a misdemeanor capias related to a charge for petty theft. I find probable cause. I see Mr. Dundas is scheduled to have a status hearing with his division judge tomorrow morning. So do the parties wish to be heard?
Not at this time, Judge.
All right, anything from the state?
No, Judge.
Okay, I'll leave the standard bonds in place. And Mr. Dundas, you'll see your division judge tomorrow morning. Good luck to you, sir. Sean Delagal.
Bonded.
All right. Jamori Veitch.
He's approaching, Judge. He's here at Maine. Mr. Veitch.
Good morning, Mr. Veitch.
Good morning.
You're before the court this morning on 2 charges. Count 1, fraud, uttering a false instrument. Count 2, possession of a counterfeit payment instrument. I find probable cause, and I'll hear from the parties.
Judge, my understanding, and speaking of Mr. Veitch, this is his first contact with the criminal justice system in his adult life. He's 21 years old. He's been here since the 6th grade. He's a registered voter, attended a local high school. Judge, he lives with his father, who works at Publix. If he has no prior contact, Judge, I'm going to be asking a ROR simply on count 2.
Okay. Mr. Linder.
He doesn't have adult priors. He does have juvenile priors. But other than that, Your Honor, considering the nature of the allegations, I don't know how much confidence, how much weight the court can give Mr. Veitch's representations. I'd ask that the bonds be kept in place, and frankly, I would hope the jail wouldn't take any cash bond in this case.
Assume if they do take a cash bond, they'll be checking it before Mr. Veitch leaves their custody. All right, I'm gonna leave the standard bond in place on 1. Count 2 will be an ROR. There will also be a no return to the Coles that is at issue in this case. Mr. Veitch, do you understand you are not to return to that location?
Yes, ma'am.
All right, thank you, sir. Good luck. Nimoy Johnson.
He's approaching, Judge. He's here at Maine.
Good morning, Mr. Johnson. Mr. Johnson, you're before the court on 2 charges. Count 1, possession of a counterfeit payment instrument. Count 2, fraud, uttering a false instrument. I find probable cause, and I'll hear from the parties.
Judge, I'm asking an ROR on count 2 on Mr. Johnson's behalf.
Okay? Let's hear from the state.
think you said it for his co-arrestee, Your Honor. Hold on one moment.
I just want to confirm whether Mr. Johnson has any prior history I need to be aware of.
I don't know. I don't have him on my list. I don't know if pretrial has anything.
My understanding also, Judge, he has no prior adult record.
Okay. All right. I will leave the standard bond in place on 1. 2 will be an ROR. And as I said, with Mr. Johnson's co-arrestee, there will be a no return to the Coles that is at issue in this case. Mr. Johnson, do you understand you are not to return to that location?
Yes, sir.
Thank you. Good luck. Jeremy Pelahowski.
He's approaching, Judge. Come on up, sir.
Good morning, Mr. Pelahowski.
Good morning.
You're before the court this morning on 3 charges. Count 1, driving while license suspended, third or subsequent offense. Count 2, having an expired motor vehicle registration over 6 months. That is not for magistrate. Count 3 is a felony probation violation with a no bond hold. I find probable cause for these charges. In light of the no bond hold, do the parties wish to be heard on count 1?
Not at this time, Judge.
All right, I will leave the standard bond in place on that matter, and sir, you'll see your division judge soon to discuss the violation of probation issue. Good luck to you. Jason Anthony Morris.
Approaching, Judge Main.
Okay, I'm being told by confinement his bond was posted. All right, so I'm going to make a finding of probable cause. Good luck to you, Mr. Morris. Taylor Wesson.
Medical reset.
All right, I've already made a finding of probable cause in his case. Anthony Malone.
Medical reset.
Okay, same thing for him. Jonathan Wasteman.
Maine.
He bonded?
Bonded, Judge.
All right, thank you. And Mr. Romero, are you ready to discuss Travis Stewart?
I am, Judge.
Okay, let's go ahead. All right, and Mr. Stewart, for the record, you're before the court this morning on 5 charges. Count 1, possession with intent to sell, manufacture, or deliver cocaine. Count 2, trafficking MDMA between 10 and 200 grams. Count 3, operating without a valid driver's license, that has a $25 bond. 4, disobeying a stop or yield sign, that is not for magistrate. 5 is a civil writ of arrest, that is not for magistrate, but just so that you know, has a purge amount of $600. I find probable cause for these charges. And Mr. Linder, were you able to check to tell me what the correct standard bond would be on count 2?
$75,000.
Okay, thank you. All right, is the state seeking anything beyond the standard bonds in this case?
No, Judge.
All right, Mr. Romero,
One moment, Judge.
go ahead.
Of course, DOC has to be down.
Judge, I spoke with Mr. Stewart. I asked him as far as how much he believes his family come up with. He says he honestly does not know. Now, at this time, Judge, my understanding is Mr. Stewart, he is working. He's working for a landscaping company where he says he's been there for 4 months, making about $400 a week. He's been here his whole entire life. He's 39 years old. He resides in Pompano Beach with his siblings, with his brother and his sister. His brother's an electrician. His sister is a secretary at an office. Also, he has an aunt that lives in Broward County that would try and help him, but her financial resources, from what he indicated, she's retired, so he doesn't think very much. Now, he's been living at the same place for the past 5 years. His monthly share of the rent with the electric and all the utilities is about $550 a month. But what he did advise me is he definitely knows that his family can't afford $75,000, but he doesn't know how much his family can come up with.
Your Honor, first off, and I know Mr. Romero's advising what his client's telling him, that he makes $400 a week. It would appear that there's supplemental income coming in. He was operating a 2018 Chevy with 32 grams of MDMA, 22 baggies of cocaine. I would note that the amount of the MDMA is really not that close to the bottom level, 10 grams. Additionally, Mr. Stewart has a history of drug dealing. In 2012, he was convicted of tampering with evidence, possession of cocaine. He was sentenced to 45 months in state prison. 2011, possession of cocaine with intent to sell, distribute. VOP, 4-year state prison. Possession of cocaine 09, delivery of cocaine 08, possession of cocaine 08, possession of cocaine with intent to sell, distribute, and introducing contraband into a detention facility 06, 17-month state prison. Possession of cocaine 06, possession of cocaine 03, possession of cocaine with intent 04, 14-month state prison. State prison. Nothing further, Judge.
All right. In light of the fact that I understand, Mr. Romero, what you've said to me based on what Mr. Stewart has said to you, but in light of that information and not knowing how much his family is going to be able to afford either way, this may be, if he's not able to post the standard bonds, it may be something that's more appropriate to handle before his division judge to have a lengthier hearing to see what information's available at that time. So for today's purposes, I'm going to leave the standard bonds in place. I'm making a correction on my finding sheet, just for the record, because it was originally showing count 2 between 200 and 400 grams. So I've made the correction so that it's between 10 and 200 grams with the $75,000 standard bond. And just so that Mr. Stewart knows, whatever happens with the standard bonds on these counts, as far as the civil writ of arrest goes, that $600 purge amount will remain because I don't have any authority to change that anyway. All right? Mr. Stewart, good luck to you. Okay, we have one case left, and that is for our interpreter. Mr. Miller, do we have any update from the interpreter?
Your Honor, I sent a second email requesting an interpreter, and I believe Sue is calling from the jail.
Okay.
And
Go ahead.
she contacted them, and they're waiting for a phone call back.
All right, why don't we, we'll go on a brief recess. He's our last one. We'll go on a brief recess to see what happens. I just need to know if they're going to have someone for us.
Or do you want to go ahead and reset it for 1 o'clock, Judge?
Well, if they're going to have somebody here within the next few minutes, we'll do it. But if they call back and say they can't, they won't have somebody here for a while, then I'll reset it. I just need to know one way or the other.
Call back right now. Call back right now. Well, we're going to call right now, Judge.
Okay, I'm going to leave it on. Let's just find out. Just so they can tell me when someone's coming.
Judge, I've just been in touch right now. I overheard the conversation. Right now, they don't have anyone available. It's better at 1 o'clock, Judge.
All right, so we'll have Mr. Hernandez Alvarez reset to 1. So if you'll let him know he's going to be coming back this afternoon, and we'll address it.
I'll let.
Thank you very much. So I'll see everyone at 1 o'clock. Thank you.